Good afternoon, everybody. My name is James McHugh, and I'm here to talk to you about interim relief. And if you think that I've come up with this topic mainly so I can talk to you at the end about a case I won in the Court of Appeal, you would be absolutely right. So a practical guide to interim relief. What is interim relief? It's been a long-established principle of English contract law that only in very limited circumstances can you obtain normal injunctive relief to either preserve an employment contract or reinstate an employment contract after termination. The Supreme Court confirmed that as recently as 2013. But in the Employment Tribunal, interim relief is an emergency interlocutory procedure that is available to claimants who have been dismissed on very specific grounds to allow them to either be reinstated or re-engaged or to have their contract protected. If you turn to the first page of my handout, I won't read through the list, but I've set out there the 10 examples or the 10 circumstances in which a claimant who has been dismissed can claim interim relief. And the Northern Irish Court of Appeal put it most succinctly in the case of Bombardier Aerospace and McConnell, in which they set out that the remedy of interim relief is designed to effectively preserve the status quo for an employee until such time as the final hearing can take place or the claim can be effectively compromised. What happens, in essence, when an order for interim relief is made is that the contract of employment is either preserved with an order for the continuation of the contract, or the employee is reinstated into their original role or re-engaged in a similar role, just in the way that would happen as a remedy for unfair dismissal. The order takes place from the date of the effective date of termination and will survive either till resolution at final hearing or in the claim being compromised by way of settlement. Mr. Justice Kavanagh, in the case of Steer and Stormshire Limited, in his 2021 Employment Appeal Tribunal judgment, gives a very useful summary of the history and legislative development in relation to interim relief. He deals with it far more eloquently than I could, and I'd encourage you, if you're interested in looking at interim relief as a remedy and how it's developed, to look at that judgment and paragraphs 27 to 40 of it. Starting an application for interim relief, and the real key point in relation to this is that time really is of the essence. Section 1282 of the ERA 1996 sets out that where the claimant thinks that they have grounds to bring an application for interim relief, they must present their claim to the tribunal within 7 days of the effective date of termination. As far as I'm aware, there is no saving provision as you would get in relation to an ordinary unfair dismissal claim or in relation to an Equality Act claim where it's not been reasonably practicable to prevent a claim in such time. If you don't bring your claim within 7 days, your application will be defeated. Once that claim has been submitted, there is an additional step, and I've set this out at paragraph 7 of my handout. There is an additional step if you are alleging as a claimant you have been dismissed for carrying out trade union activities. In those circumstances, not only do you have to get your application in within 7 days of the EDT, but you also have to get a signed certificate from the union confirming that at the date of dismissal, the employee was a union member, and that according to the union, there appear to be reasonable grounds for supposing that the reason for dismissal was trade union-related activities. It's worth touching on that for a moment because there is case law that says that whilst obtaining a certificate from your union is not determinative of the application, the tribunal will recognise that the union will effectively be putting themselves out on a bit of a limb by signing a certificate saying that there appear to be reasonable grounds for supposing that the reason for dismissal was a trade union related reason. And the tribunal is to deal with the appearance of a certificate like that as an influential factor in deciding whether to grant interim relief or not. The tribunal's got to determine an application for interim relief as soon as is practicable after receipt. And once the hearing for an interim relief application has been listed, that application can't be postponed unless the tribunal is satisfied that special circumstances exist which justify it in doing so. Again, the jurisprudence in relation to this means it is a sterner test than a test for just an ordinary adjournment. It is only in the rarest of circumstances that a postponement will be granted in cases where there is an application for interim relief. Turning then to the hearing itself and what the tribunal is required to consider. Interim relief applications are heard by judges alone, and they are to be treated like public hearings, just as an application to strike out would. So they'll be dealt with in the same way as a public preliminary hearing would be, and they've got the same status as a public preliminary hearing. Normally, the position is that the tribunal won't hear oral evidence at an interim relief application. The application will be determined either just on the papers or, if there's legal representation, on the papers and with legal submissions. The tribunal does have the power to direct oral evidence at an interim relief application, but again, it will only do so in very specific and rare circumstances. The purpose, effectively, is to be like an application for an interim injunction in the county court or the high court. It's to look at whether or not they're on a paper assessment, whether there is a good chance of obtaining it or not. So it's only in very unusual circumstances that oral evidence will be directed. The main question that the tribunal will be considering is whether it appears to the tribunal that it's likely, on determining the substantive complaint to which the application relates, the tribunal will find that the reason, or obviously if there's more than one reason, the principal reason for the dismissal is one of the prohibited reasons that I'd set out previously at paragraph 1 of my handout. Somewhat predictably, lawyers have been unable to agree on what the definition of the word likely is. And so there's had to be a series of cases determining what exactly was meant by the phrase in the legislation, "it is likely." The first of those cases was the case of Taplin and Shipham. That's a 1978 case in the Court of Appeal. What Taplin said was, "it is likely" ought to be interpreted as a pretty good chance of succeeding at a final hearing. Now, you will be shocked again to learn that people couldn't agree on what the phrase "pretty good chance" meant. That required further jurisprudence. And so in the 2011 case of the Ministry of Justice and Safraz, the EAT gave further guidance stating that likely connotes a significantly higher degree of likelihood than more likely than not. Answers on a postcard, please. In the case of London City Airport and Chaco, which is a 2013 EAT case, the EAT made clear that what's not happening at an interim relief hearing is a full merits assessment of the claim. But what the tribunal has to make a decision on is on an expeditious summary assessment of the untested material available to it, is it likely that the main reason for dismissal was a prohibited one? Interestingly, in the 2020 case of Simply Smile Manor House and Terberg, the EAT found that the likely to succeed test has to be applied to every aspect of the complaint. So, for example, in the Simply Smile case, there was a dispute about whether the claimant bringing the claim was a worker or whether they were an employee, and whether or not they had standing in the first place to bring a claim for unfair dismissal. The likely to succeed test applied to that element of the claim as well as the reason for dismissal element of the claim. If you're able to persuade the tribunal that it is likely that the dismissal was for one of the prohibited reasons, the question that follows is, what orders can the tribunal make? And in a lot of ways, it's similar to the remedy process that starts if you're successful in an unfair dismissal claim. the first question that has to be asked of the employer, and the primary remedy in relation to an application for interim relief, is whether or not the employer or the employee are willing to be reinstated or re-engaged. If the employer says, no, they're not willing to reinstate or re-engage, or if the employer fails to attend the interim relief application hearing, then the tribunal will make a separate order instead for continuation of the employee's contract of employment. It's worth pausing there to think of both benefits of the claimant and detriments to the respondent of an order in those terms. An order under section 1299 of the ERA effectively places the claimant in a position where they receive their full pay and any other associated benefits that they were entitled to under their contract of employment, right through to either disposal of the claim or such time as the claim is settled. Now, this is less of an issue in regions like Newcastle, where although listings are not great, they're still accommodating lengthy hearings relatively quickly. But in regions like Manchester, or if any of you have tried to get a multi-day claim listed in Watford, London Central, or anywhere like that recently, you'll know that you're looking at a delay of at least 18 months for a multi-day hearing. It puts significant pressure on a respondent to settle a claim and is a bit of a disincentive to the claimant to try and mitigate their loss, because in the interim period, why would they want to look for alternative employment when they are sat earning full pay from their employer? It's even more significant when, as Mr. Justice Kavanagh confirmed in his summary of the law in Steer, even if the Employment Tribunal claim is ultimately unsuccessful at the final hearing, the claimant doesn't have to repay the money that they've been paid whilst they've been subject to the benefit of the interim relief order. The only tactical move that you could potentially recommend for an employer is to look at whether or not, and I understand that in a number of cases this won't be suitable at all, but whether or not they could make an offer to reinstate or re-engage and effectively call the employee's bluff. Because in circumstances where there is an offer of reinstatement or re-engagement, there is a refusal of that offer by the claimant, and the tribunal deems that refusal to be unreasonable. That is a ground for refusing to grant the claimant the relief that they are seeking. The last thing I want to talk to you about is about a recent attempt to expand the scope of interim relief beyond claims that are limited to effectively union activity and union adjacent activity and whistleblowing. And a recent attempt made to expand interim relief to include the scope of all discrimination-related dismissals. That case was Steer and Stormshire Limited, and I'll briefly run you through the facts in that. In Steer, the claimant was employed by the respondent for a total of approximately 4 months. During that period, Mrs. Steer alleges that she was subject to a number of instances of sex-based harassment. They were not limited to inappropriate conduct from colleagues, her hours being reduced because they felt that she couldn't cope in relation to her childcare commitments, and when a request was made to work from home, screen monitoring software being installed on her computer, even though it wasn't installed on any of her colleagues' computers. Ultimately, what happened was, in approximately July of 2020, the claimant resigned and, amongst other things, made claims of constructive dismissal, automatically unfair constructive dismissal, direct discrimination on the grounds of sex, sex harassment, and victimisation. The claimant was funded by the Equality and Human Rights Commission to bring a claim to the Watford Employment Tribunal and at the same time make an application for interim relief. Initially, she brought a claim for whistleblowing and so was within the scope of an application for interim relief. The Watford ET listed an interim relief application for the whistleblowing claim, but wrote to the claimant and said, we can't list an interim relief application for your discrimination complaints because we've got no jurisdiction to do it. This resulted in the claimant appealing to the Employment Appeal Tribunal and arguing that the failure to permit her the remedy of interim relief on the grounds of discrimination was a breach of both existing EU law and in particular the principle of equivalence, and also a breach of her rights under the European Convention of Human Rights via the Human Rights Act. What the claimant suggested was that the Employment Tribunal ought to have construed the Equality Act in such a way as to read in the provisions entitling her to the remedy of interim relief. The appeal was heard in front of Mr. Justice Kavanagh, and it had to be expedited to ensure that it took place before Brexit Day, because it involved various tricky issues of EU law, and the time was running out before we effectively exited the European Union. And so any case law decision that was going to be binding any case law decisions had to be made before Brexit Day kicked in. The Employment Appeal Tribunal found at first instance that there was no breach of EU law, effectively saying that there was no issue in the equivalence between remedies available to discrimination claimants and remedies available to those who had been subject to automatic unfair dismissal on protected grounds that would entitle you to claim interim relief. In particular, what they found was that whilst, yes, discrimination meant you couldn't claim interim relief, there were associated benefits both in terms of compensation and the losses that you claim that made up for that and made up for the fact that interim relief was unavailable. What the EAT did find, however, was that it was open to the claimant to establish a potential breach of the Human Rights Act, and that was because, unfortunately, at EAT stage, the government, though invited to participate in the appeal, declined to do so, and the respondent, as a private employer, was not in a position to justify the government's decision to not provide interim relief as a remedy to those who've been dismissed on grounds that were discriminatory. Fortunately for the government, when the matter was referred up to the Court of Appeal to make potentially a declaration of incompatibility with the European human rights law, the government intervened at that stage. And the Court of Appeal found that, in fact, once the government intervened and made further arguments, the lack of interim relief didn't breach the claimant's human rights, but that even if it did, that breach could be justified. And one of the main reasons they cited for justification was the potential impact on Employment Tribunal resources if interim relief went from a very narrow scope in the limited exceptions that I've talked about in this handout to any sort of dismissal that had a discriminatory element to it. One of the statistics that they quoted was that there had been in the year prior to the appeal being heard, there had been approximately 150 applications nationwide for interim relief, whereas there had been approximately between 9,000 and 9,500 claims alleging sex discrimination alone, never mind other elements of discrimination. What the Court of Appeal effectively found was that it would have a potentially significant impact on tribunal resources if that relief had been expanded beyond the scope of just union-based activities and whistleblowing. However, there was an attempt to have the Supreme Court consider the issue. Permission to appeal to the Supreme Court was refused in July 2022, but I'm aware from those who were involved in the case that behind the scenes, the Equality and Human Rights Commission continues to lobby the government to extend the scope. Their arguments are getting some traction, I'm told, with civil servants, but obviously at the moment, the current government have no interest in expanding those sorts of protections. But if there is a change of government following a general election, I would be very interested to see whether there are any legislative developments in this area, because certainly from what I've heard, there are continued attempts on a legislative basis to expand this right, and it may well be in the future that interim relief is expanded further.